Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Ciminelli v. United States. In this case, the court considered this issue. Does the Second Circuit's right to control theory of fraud state a valid basis for liability under the federal wire fraud statute? The case was decided on May 11, 2023. The Supreme Court held that the Second Circuit's right to control theory cannot form the basis for a conviction under the federal fraud statutes because the right to control is not grounded in a traditional property interest. Justice Clarence Thomas authored the unanimous opinion of the court. The federal wire fraud statute prohibits the use of interstate wires for any scheme or orifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. When the statute was enacted, the common understanding of the verb to defraud related to property rights. Although lower courts have interpreted the statute to include interests unconnected to traditional property rights, the Supreme Court in McNally v. United States held that the statutes protect only individual property rights. The right to control theory has no roots in a traditional property interest, and thus cannot be the basis for a conviction under the federal fraud statutes. The opinions are presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. In this case, we must decide whether the Second Circuit's long-standing right to control theory of fraud describes a valid basis for liability under the federal wire fraud statute, which criminalizes the use of interstate wires for any scheme or artifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. Under the right to control theory, a defendant is guilty of wire fraud if he schemes to deprive the victim of potentially valuable economic information necessary to make discretionary economic decisions. Petitioner Louis Ciminelli was charged with, tried for, and convicted of wire fraud under this theory, and the Second Circuit affirmed his convictions on that same basis. We have held, however, that the federal fraud statutes criminalize only schemes to deprive people of traditional property interests, because potentially valuable economic information necessary to make discretionary economic decisions is not a traditional property interest. We now hold that the right to control theory is not a valid basis for liability under Section 1343. Accordingly, we reverse the Second Circuit's judgment. This case begins with then New York Governor Andrew Cuomo's Buffalo Billion Initiative. On its face, the initiative was administered through Fort Schuyler Management Corporation, a nonprofit affiliated with the State University of New York, SUNY Research Foundation. It aimed to invest $1 billion in development projects in upstate New York. Later investigations, however, uncovered a wide-ranging scheme that involved several of former Governor Cuomo's associates, most notably Elaine Colliaros and Todd Howe. Colliaros was a member of Fort Schuyler's board of directors and was in charge of developing project proposals for Buffalo Billion. Howe was a lobbyist who had deep ties to the Cuomo administration. Each month, Colliaros paid Howe $25,000 in state funds to ensure that the Cuomo administration gave Colliaros a prominent position in Buffalo Billion. Ciminelli had a similar arrangement. His construction company, LP Ciminelli, paid Howe $100,000 to $180,000 each year to help it obtain state-funded jobs. In 2013, Howe and Colliaros devised a scheme whereby Colliaros would tailor Fort Schuyler's bid process to smooth the way for LP Ciminelli to receive major Buffalo Billion contracts. First, on Colliaros' suggestion, Fort Schuyler established a process for selecting preferred developers that would be given the first opportunity to negotiate with Fort Schuyler for specific projects. Then, Colliaros, Howe, and Ciminelli jointly developed a set of requests for proposal, RFPs, that treated unique aspects of LP Ciminelli as qualifications for preferred developer status. Those RFPs effectively guaranteed that LP Ciminelli would be, and was, selected as a preferred developer for the Buffalo projects. With that status in hand, LP Ciminelli secured the marquee $750 million Riverbend project in Buffalo. After an investigation revealed their scheme, Ciminelli, Howe, Colliaros, and several others were indicted by a federal grand jury on 18 counts including, as relevant here, wire fraud in violation of 18 U.S.C. Section 1343, and conspiracy to commit wire fraud in violation of Section 1349. Throughout the grand jury proceedings, trial and appeal, the government relied on the Second Circuit's right to control theory, under which the government can establish wire fraud by showing that the defendant schemed to deprive a victim of potentially valuable economic information necessary to make discretionary economic decisions. The government's indictment and trial strategy rested solely on that theory, and it successfully defeated Ciminelli and his co-defendants' motion to dismiss by relying on that theory. In addition, it successfully moved the district court to exclude certain defense evidence as irrelevant to that theory. The government also relied on that theory in its summation to the jury. Consistent with the right to control theory, the district court instructed the jury that the term property in Section 1343 includes intangible interests such as the right to control the use of one's assets. The jury could thus find that the defendants harmed Fort Schuyler's right to control its assets if Fort Schuyler was deprived of potentially valuable economic information that it would consider valuable in deciding how to use its assets. The district court further defined economically valuable information as information that affects the victim's assessment of the benefits or burdens of a transaction, or relates to the quality of goods or services received, or the economic risks of the transaction. The jury found Ciminelli guilty of wire fraud and conspiracy to commit wire fraud, and the district court sentenced him to 28 months imprisonment followed by 2 years supervised release. On appeal, Ciminelli challenged the right to control theory, arguing that the right to control one's assets is not property for purposes of the wire fraud statute. Defending the wire fraud convictions, the government relied solely on the right to control theory. The Second Circuit affirmed the convictions based on its long-standing right to control precedents, holding that, by rigging the RFPs to favor their companies, defendants deprived Fort Schuyler of potentially valuable economic information. We granted certiorari to determine whether the Second Circuit's right to control theory of wire fraud is a valid basis for liability under 18 U.S.C. Section 1343, and we now hold that it is not. The wire fraud statute criminalizes schemes or artifices to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. Although the statute is phrased in the disjunctive, we have consistently understood the money or property requirement to limit the scheme or artifice to defraud element, because the common understanding of the words to defraud when the statute was enacted referred to wronging one in his property rights. This understanding reflects not only the original meaning of the text, but also that the fraud statutes do not vest a general power in the federal government to enforce its view of integrity in broad swaths of state and local policymaking. Instead, these statutes protect property rights only. Accordingly, the government must prove not only that wire fraud defendants engaged in deception, but also that money or property was an object of their fraud. Despite these limitations, lower federal courts for decades interpreted the mail and wire fraud statutes to protect intangible interests, unconnected to traditional property rights. For example, federal courts held the fraud statutes reached such intangible interests as the right to honest services, the right of the citizenry to an honest election, and the right to privacy. In McNally v. United States, this court halted that trend by confining the federal fraud statutes to their original station, the protection of individual property rights. Congress then amended the fraud statute specifically to cover one of the intangible rights that lower courts had protected under the statutes prior to McNally, the intangible right of honest services. The right to control theory applied below first arose after McNally prevented the government from basing federal fraud convictions on harms to intangible interests unconnected to property. As developed by the Second Circuit, the theory holds that, since a defining feature of most property is the right to control the asset in question, the property interests protected by the wire fraud statute include the interest of a victim in controlling his or her own assets. Thus, a cognizable harm occurs where the defendant's scheme denies the victim the right to control its assets by depriving it of information necessary to make discretionary economic decisions. The right to control theory cannot be squared with the text of the federal fraud statutes, which are limited in scope to the protection of property rights. The so-called right to control is not an interest that had long been recognized as property when the wire fraud statute was enacted. Significantly, when the Second Circuit first recognized the right to control theory in 1991, decades after the wire fraud statute was enacted and over a century after the mail fraud statute was enacted, it could cite no authority that established potentially valuable economic information as a traditionally recognized property interest. And the Second Circuit has not since attempted to ground the right to control theory in traditional property notions. We have consistently rejected such federal fraud theories that stray from traditional concepts of property. For its part, the government, despite relying upon the right to control theory for decades, including in this very case, now concedes that if the right to make informed decisions about the disposition of one's assets, without more, were treated as the sort of property giving rise to wire fraud, it would risk expanding the federal fraud statutes beyond property fraud as defined at common law, and as Congress would have understood it. Thus, even the government now agrees that the Second Circuit's right to control theory is unmoored from the federal fraud statute's text. The right to control theory is also inconsistent with the structure and history of the federal fraud statutes. As recounted above, after McNally put an end to federal courts' use of mail and wire fraud to protect an ever-growing swath of intangible interests unconnected to property, Congress responded by enacting Section 1346, which, despite the wide array of intangible rights courts protected under the fraud statutes pre-McNally, revived only the intangible right of honest services. Congress, reverberating silence about other such intangible interests, forecloses the expansion of the wire fraud statute to cover the intangible right to control. Finally, the right to control theory vastly expands federal jurisdiction without statutory authorization. Because the theory treats mere information as the protected interest, almost any deceptive act could be criminal. The theory thus makes a federal crime of an almost limitless variety of deceptive actions traditionally left to state contract and tort law, in flat contradiction with our caution that, absent a clear statement by Congress, courts should not read the mail and wire fraud statutes to place under federal superintendents a vast array of conduct traditionally policed by the states. And, as it did below, the Second Circuit has employed the theory to affirm federal convictions regulating the ethics, or lack thereof, of state employees and contractors, despite our admonition that federal prosecutors may not use property fraud statutes to set standards of disclosure and good government for state and local officials. The right to control theory thus criminalizes traditionally civil matters, and federalizes traditionally state matters. In sum, the wire fraud statute reaches only traditional property interests. The right to valuable economic information needed to make discretionary economic decisions is not a traditional property interest. Accordingly, the right to control theory cannot form the basis for a conviction under the federal fraud statutes. Despite indicting, obtaining convictions, and prevailing on appeal based solely on the right to control theory, the government now concedes that the theory as articulated below is erroneous. The government frankly admits that, to the extent that language in the Second Circuit's opinions might suggest that depriving a victim of economically valuable information, without more, necessarily qualifies as obtaining money or property within the meaning of the fraud statutes, that is incorrect. That should be the end of the case. Yet the government insists that its concession does not require reversal because we can affirm Ciminelli's convictions on the alternative ground that the evidence was sufficient to establish wire fraud under a traditional property fraud theory. With profuse citations to the records below, the government asks us to cherry-pick facts presented to a jury charged on the right to control theory, and apply them to the elements of a different wire fraud theory in the first instance. In other words, the government asks us to assume not only the function of a court of first view, but also of a jury. That is not our role. Accordingly, we decline the government's request to affirm Ciminelli's convictions on alternative grounds. The right to control theory is invalid under the federal fraud statutes. We, therefore, reverse the judgment of the Court of Appeals, and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Alito, concurring. The opinion of the court correctly answers the sole question posed to us, whether the right to control theory supports liability under the federal wire fraud statute. The jury instructions embody that theory, and therefore this error, unless harmless, requires the reversal of the judgment below. I do not understand the court's opinion to address fact-specific issues on remedy outside the question presented, including 1. Petitioner's ability to challenge the indictment at this stage of proceedings. 2. The indictment's sufficiency. 3. The applicability of harmless error to particular invocations of the right to control theory during trial. And 4. The government's ability to retry petitioner on the theory that he conspired to obtain, and did in fact obtain, by fraud, a traditional form of property, viz., valuable contracts. On this understanding, I join the court's opinion. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.